Okay, I want to welcome you to what small businesses need to know in considering bankruptcy. We have David Berman with us. He has a lot of great information to share with you, and things for you to think through, if this is something you're considering. But before we get started with his presentation, I just want to make sure that you are taking advantage of all the things that SCORE has to offer. Our goal is to share small business information with you, and we do that in a couple of different ways. One is through our website, score.org. There are podcasts, blogs, recordings, articles, templates you can download, lots of great information. So if there's something small or specific that you're looking for, head over and take a look, or you just have a lunch break and want to watch something, listen to a podcast or something on small business, you'll find some there. The other way we share small information, business information, is through our workshops. Those are advertised via social media, on our newsletter, and of course are also listed on our website. The most important thing that SCORE does, however, is the mentoring. And our mentors are volunteers. They have a variety of skills and experiences that they want to share with you. A beginning session will be them learning about you, what your goals are, what your challenges are, and working with you to make a plan so that you can be successful. It's not uncommon that your primary mentor will bring in others to help co-counsel or refer you to others as your needs change and as you work along the path towards your goal. So I strongly suggest reaching out and getting a mentor today, because it's a wonderful experience to hear from someone else on different ideas. So getting that mentor you want to know next is very easy, multiple ways on the website. Probably the absolute easiest is to go to the score.org website and look for the box that says, let us do the matching for you. You just put in your zip code and that'll match you to the chapter that's nearest you. There's a short form, and that we're looking for information on how we can help you right now, what kind of business you have. We'll use that information to match you to the appropriate mentor to help you in your current situation. I know this slide says Q&A, but I'll be watching chat as well, so you can put questions into the Q&A or the chat, and we will try and get to as many questions as possible. We are recording, and that recording will be posted in the next 24 to 48 hours on score.org/Boston. If you look from the graphic there, look under the local workshops pull down on the blue bar, and you'll find our previously recorded offerings. So I'm going to go ahead and turn it over to David. It's all yours.
Oh, thank you. Thank you. Welcome, everybody. I'm just going to put up a little slide on the screen. I think the seminar said what you need to know about bankruptcy, and what you need to know is you don't want to do it unless you have to. Uh, Bankruptcy should be a last alternative. If you can do anything out of court, that's probably a better way to do it. Once you get into the court, you're going to lose control. I mean, you'll have your counsel, but the judge is going to make decisions based on the law. Creditors will have some input. The U.S. government has a U.S. trustee that oversees the case and makes contact. So you're not going to necessarily be able to do what you want to do. So my first piece of advice is always to try other alternatives first. If you're having trouble with your mortgage holder, try to negotiate a deal with him. If you're having trouble with your landlord, the same. If you're having cash flow problems, there are professionals that can try to help you to get that under control. And as I said, bankruptcy is the last alternative, because it also tarnishes your credit rating, and while a lot of businesses file bankruptcy, not a lot of them successfully come out. So let's talk about bankruptcy, though, if that's something. And there's a lot of planning that you need to do. And bankruptcy costs money, another reason to try to avoid it, although as a lawyer, I love being paid for bankruptcy. But first of all, you need a professional team to help you. It's not something that you should do or can do without counsel. So you'll have to find an attorney, and you'll also need to work with somebody who's familiar with accounting to try to help you manage your numbers, do some projections for you, and see exactly what it's going to be. Um, and as part of that, seeing the numbers, you'll probably prepare a cash flow showing the bankruptcy impact. And the cash flow will be different than it would be outside the bankruptcy. Outside the bankruptcy, you're paying your employees every week, you're paying your vendors as you need to, as it comes due. And at bankruptcy, there are certain things, whatever you owe prior to the bankruptcy, you're not going to have to pay on a monthly basis. So that if I'm a vendor and you owe me $10,000 and you file bankruptcy, you're not going to pay me that 10,000 in the bankruptcy. You'll do something to restructure it or settle it as a result of the bankruptcy, but that $10,000 you won't pay me in the bankruptcy. But if you buy goods from me in the bankruptcy, you pay currently for those goods. Um, if you're going to be continuing your business, looking at the cash flow, are you going to have sufficient cash flow to pay your bills as they mature after the bankruptcy? Are you going to be able to pay for your goods you need to purchase? Are you going to be able to pay your employees and so on and so forth? And if not, do you need to go out and find a loan? And when I was practicing law, now being retired for 9 years, unbelievably so, uh, we spent months with people trying to arrange financing. Now, they were not your small business companies, but it takes time for the lender to get to know you. If you don't have an existing lender, the lender will want to see your projections. The lender will want to see what its collateral is and if it can get paid. So there's a lot of financing preparation that you need to do if you're going to need to obtain a loan to operate a working capital loan in the bankruptcy. Um, then, of course, your business in the bankruptcy is going to be dependent upon your trade continuing to support you. What you may find when we talk about preparation of cash flow is that your vendor would give you 30-day terms. In the bankruptcy, they may want cash before delivery, cash on delivery. They may not be willing to take the risk of giving you credit in the bankruptcy. So that's going to affect your cash flow. I've even had bankruptcies where the vendors refused to ship at all and just told the company to liquidate. A notable one being Circuit City, if everybody remembers good old Circuit City. The vendors said, we're not going to support this company anymore. And that led to a liquidation of Circuit City. So you need to deal with your vendors. If you have some crucial vendors, there is a way that you can somehow give them some preference. And by that, I mean, you could say to the court that these guys are so crucial. Without them, I have no other source for this, uh, so on and so forth. So not only do I need to pay them currently, but I want to pay them some of their arrearage so they stick with me. There are specific rules regarding that. It's not a given that you'll be able to get that through, but there are ways to deal with vendors. Employees, if you have employees, you don't want the employees, uh, looking for new work because you're in bankruptcy. You want to keep them as part of your business because they're key. Maybe not everybody, but I'm sure you'll all have key employees that you want to keep. Through the bankruptcy court, there are ways that you can give them bonuses if they stay with you, so that if they stay with you throughout the bankruptcy, they get a bonus at the end, um, and the like. But you can need to deal with the employees to keep them there. Now, question is, when do you deal with the employees? Um, you don't want to tell them too soon because that may freak them out and they may go leave. At the same time, you don't want to keep them in the dark all the time and then spring it on them. So it's a timing issue in terms of talking to your employees, whether you're talking to just the key employees, all the employees. Obviously, after you file, it would be nice to have a meeting with all your employees to comfort them and give them assurance and the like. But you need to think this through. This is all part of the planning. This isn't the execution comes after the planning. How are we going to deal with our employees? Do we need to keep the employees? Are we going to lay people off? Uh, so on and so forth. Utilities, you know, if you're behind in utility payments, um, you need to deal with your utilities. In the bankruptcy, the utilities have the right to ask for a deposit to cover future usage. But that can usually be negotiated in advance in terms of what the utilities are going to require. And because that's going to affect your cash flow. If utilities say, I want, 3 months deposit, you need to have the cash to do that, or have a lender give a letter of credit or something of the sort. So negotiating with utilities in advance is fine. Uh, your lease, we'll talk further about leases later, but the key thing to a lease in the bankruptcy is if you file before the landlord terminates the lease for breach, then you'll be able to continue to use the premises in the bankruptcy, paying the current monthly rent and not worrying about the arrearage at the outset. If you file your bankruptcy after the landlord has terminated the lease, then you really don't have a lease to protect, and you may not be able to stay in the building. So you need to understand where you stand with your landlord, and if possible, at certain times, negotiate with the landlord to, get a rent deferral once you file the bankruptcy, or readjust the rent for a period of time, or whatever. Um, Timing of filing is important. I used to be involved with a lot of retailers, and they like to file in November. Why did they like to file in November? Because Christmas season, and they were always cash heavy Christmas season. People would buy, they'd have a lot of cash to operate, as opposed to doing it in February when sales were down and cash uh, was at a premium. So timing is something to talk to your attorney about. You don't always have control of the timing. Sometimes you need to file because you have to stop a landlord from evicting you, or a mortgagee from foreclosing, or for other reasons. So you don't always have control of timing, but many times the company will try to control the timing to file at an opportune time. Then there are a bunch of paperwork you have to file with the court. You have to prepare schedules, which are going to state all of your assets and all of your liabilities, names of all your creditors, how much you owe them, all of your assets, statement of affairs. Will ask you various questions about your business operations. And then there are a bunch of first day motions, because once you file bankruptcy, you can't operate as usual. So, for example, let's assume you pay your employees once a month, and you file in the middle of the month. Well, you're not going to be able to pay the employees for the period of time they worked before you're filing. You need to get a court order allowing you to do that. And that's not necessarily a hard order to get, because the court understands you have to pay the employees to keep them, but you just can't pay them at the end of the month for the whole month. You need the court to say you're authorized to pay, pre-petition earned wages. Similarly, sales taxes, for example, there's going to be sales taxes for a period of time before you file that haven't been paid yet. You're going to want the court to let you pay your tax obligations whenever they arise, whether it was for pre or post filing. Excuse me one second. Um, and you're going to need authorization to, deal with, if you have customer gift programs, gift cards, you can't honor those unless the court allows you to honor those, because that's a pre-petition obligation. So there are a bunch of paperwork and planning that goes into filing the bankruptcy, and it's not going to be an overnight process. Okay. Now let me move to the next slide. assuming I can. All right. Now, if you file a bankruptcy, um, there's what's known as the automatic stay, which means that creditors cannot take action to against you, legal action. So if somebody's suing you for a bad debt, that is put on hold. If a bank is threatening to foreclose the mortgage, that's put on hold. The landlord's threatened to evict you, that's put on hold. Now, there are ways that creditors can get the court to say, okay, you can go forward. They have to show cause, or they have to show that there's no value in the asset and it's not necessary. So, for example, if you had financed a piece of machinery and um, you know, and the bank had a lien on it, but you didn't need it anymore for your business because you're changing your production, they could come in and say, listen, there's no value in the machinery. We're lucky if we can get out on it, and the company doesn't need it. So let us please go forward and sell that machinery to reduce our debt. Um, you know, for cause is, there are many reasons for cause. Um, that anyone can come up with. Um, but the third thing to mention is if you're a company that just owns one piece of real estate, you have to uh, file a plan within 90 days uh, that's reasonable plan. Otherwise, the mortgagee after 90 days can get relief and go foreclose. Um, Important thing is the stay applies against the person filing the bankruptcy. So if you have a bank loan to your company, but you've personally guaranteed it, if your company files bankruptcy, uh, then the bank can't go after the company, but they could sue you on your guarantee. And if you had given a mortgage on your home to secure your guarantee, they could try to foreclose the mortgage on your home. Uh, you know, I won't go into how we can get around that, but that's the general rule. So that by filing the company, you have to think about, do I need to personally file as well? Or can I just file the company and negotiate and work with the bank um, going forward so that they don't come after me personally? Um, we talked about first day orders briefly before, about the pre-petition wages, the gift cards, the taxes. Um, the other thing that I want to highlight here is use of cash collateral and approval of financing. If you have a bank loan, a line of credit with the bank, and the bank has a lien on your receivables and inventory, then technically you cannot use the cash generated from those receivables and inventory without an order of the court. And and similarly, if you're looking for a bank to finance you during the bankruptcy, you cannot enter into that loan arrangement without approval of the court. So therefore, as I said, when you file, there are more restrictions on you. You need to go to the court on the first day you file and say, Judge, I need to use my cash. I know the bank has a lien on the receivables and inventory, and this is how the bank's protected. And there are different ways of protecting the banks, and the bank's lien sort of terminates as of the date that you file. So if you had inventory the day you filed, and then you bought some the day after you filed, the bank's lien wouldn't extend to that inventory on the day after you filed. So one thing you do to make the bank feel comfortable is, we'll give you a lien on all the inventory and receivables we create after we file. Or you could say to the bank, I'll give you a mortgage on the building. You don't have a mortgage, I'll protect you that way. Or you can say, I'll just keep paying you principal and interest, whatever it may be. But you need to, unless the bank consents, you need to get court approval to use your proceeds from your inventory and receivables, and or to get financing starting on the day that you file. And I note I use the word interim approval of financing because even if the court says you can have financing starting today, the court's going to limit the amount that you can borrow based upon your cash flow and your cash needs. And B, is going to set up a further hearing at which time others can come in and object. The day that you file, oftentimes the creditors haven't organized, or the other parties involved in the case don't have notice and an opportunity to prepare. So the judge will set a hearing within 15 days or so to say, okay, come back then, and we'll see what they have to say about you using the receivables and inventory proceeds or continuing with this financing. Um, all right. So we talked about the utilities, how they can't cut you off because of pre-petition charges. But, within 20 days after filing, you have to give them cash deposit, letter of credit, or other security to secure the performance of your bankruptcy obligations to it. As I said, sometimes you negotiate this before bankruptcy, sometimes you use the 20 days to negotiate it. It depends upon, the nature of the utilities, the amount owed, your desire to try to minimize what you have to put up. Um, the next limitation you need to be aware of in the bankruptcy is that you need court approval to sell a lot of your assets. Not if you're a retailer and you're selling inventory in the ordinary course. Let's say you're a CVS location. So, you're selling your deodorants and your razors and everything in the ordinary course. You don't need court approval for that. But let's assume that you as CVS said, we want to sell all of our non-medical products, all our stationery, all our sodas, all our food in a bulk sale to somebody. We don't want to be in that business anymore. That's not ordinary course sale. You're now selling something outside of the ordinary course of business, and you need to go to the court to get approval for that sale. And so it's, operating on a day-to-day basis, probably not an issue. But if you need to raise cash by saying, I'm getting out of this line of business and I'm going to get rid of this equipment, I don't need it anymore, I can use the cash from it. Or if you, let's say you own your real estate and you want to sell the real estate and take the cash and lease back the real estate from the new owner, that's not an ordinary course sale. And so you would need court approval. And there are additional protections built in if you're selling customer lists, which as an ongoing business, you may not sell, but at some point in time, maybe you do. Let's assume, and I know we're small businesses, not big businesses, but let's assume you had two divisions and you decided you're just going to focus on one, and there were two different customer lists, like you're Procter and Gamble and you have a food business and a healthcare business, and you're going to get out of the healthcare business. So you have certain customers who buy your healthcare products, and somebody may be very interested in acquiring that customer list. And there are various restrictions and prohibitions and requirements that have to be met to sell a customer list. I'm sure you've all gone online and it says you can opt out and we don't sell you read privacy policies and so on and so forth. But, in a bankruptcy, the customer list is saleable as long as certain conditions are met. And customers have a lot of value. So depending upon what your plan is for future operations, you can sell the customer list as well. We talked a little bit about financing. Most banks and lenders aren't going to give you money on an unsecured basis in a bankruptcy. They're going to want either a priority, and a priority means that they're going to be the first to be paid after your secured lenders, or more than likely, and that's not necessarily a something that they do alone. Usually, when I represented lenders, they wanted a lien plus priority if the lien wasn't sufficient. They could take a second lien on an asset. If you have a piece of real estate that has a first mortgage of 200 and the property is worth 600, they could give you $200,000 and take a second lien behind the first on the real estate. Or if you have a piece of real estate that's free and clear. It doesn't have a mortgage. They could take a lien on that to give you uh, cash. And also, and this is where most of the fights I came into when I was involved in bankruptcy, secured by a priming lien. So let's assume you go into bankruptcy and you have a lien on your receivables and inventory and machinery and equipment in favor of Bank of America. And Bank of America doesn't want to continue to finance you. So you go to Chase, JP Morgan Chase, and Chase says, sure, I'll do it. And they say, but on one condition, that I know Bank of America is the first lien now. I want the first lien. I want to come ahead of them, and they come behind me. And you can do that in a bankruptcy, uh, not without fights from Bank of America in this example, uh, but you can do it in the bankruptcy as long as Bank of America is adequately protected. And by adequately protected, it means that they should be in no worse position by virtue of Chase having come in front of them than they would have been if Chase didn't exist. So, for example, I'm just going to use real estate as an example because it's easy. Bank of America has the first mortgage of $250,000 on your business real estate, and the property's worth $1 million. All right, if Bank of America foreclosed today, they clearly get their $250,000 paid back. If Chase comes in and gives you a $300,000 mortgage, so now for Bank of America, you get paid out in full. It has to get the 300 to pay Chase plus the 250 to owed it. That is 550. If the property's worth $1 million, no harm, no foul. They still should be protected every day of the week. So if there's enough equity in the assets on which they are being subordinated to the new lender, then they're adequately protected. There's other ways you can protect them. You can continue to pay them principal and interest as time goes on to reduce their debt slowly. You can use some of the proceeds from the Chase loan to pay them down. You could give them let's assume the real estate, in my example, wasn't worth $1 million, but was worth, 500,000. So now they're put $50,000 underwater. You could give them a lien on other assets that were worth $50,000 or more to protect them. And then the old indubitable equivalent, which basically means whatever else you can come up with, the court will buy that protects the lender. But, as I said, a lot of the fights that I had in bankruptcy were whether we could prime an existing lien and push it down in the priority scale on the assets. But if you don't need financing or don't have financing, it may not be an issue. Leases. This is probably a key point. As I said, if the lease has been terminated, you have nothing to protect. If the lease hasn't been terminated, then in the bankruptcy, you can pay your current lease payments and not have to pay the arrearages during the pendency of the bankruptcy. But then what you need to do is you have the option to say to the court, I don't want to keep this lease anymore. I want to get out of the lease. Or you can say to the court, I like this location. I need this location. I want to keep the lease. So you have 120 days after you file your bankruptcy to decide, do I want to keep this place or not keep this place? For example, to use Circuit City as an example, before the vendors shut the door on them, they had locations all across the country. And, we read in the paper every day how, retailers are closing stores and opening stores and whatever. So Circuit City would go through and say, these 75 stores aren't making it for us, so we're going to reject the lease and cease doing business at those stores. And they can do that. They have to terminate the lease and, get out of the location, and they don't have to pay for any period of time remaining on the lease that they don't use. And I say that they don't pay during the pendency of the bankruptcy. We'll talk about what happens at the end of the bankruptcy. Or they can say, I love this location. It's my big money maker. And therefore, I want to continue here. If you're going to continue, and the second bullet here says you have to ultimately cure all defaults, which means you'd have to pay the landlord all of its arrearages. And then you would also have to give the landlord assurance of future performance. Now, how does that come about? Most of the time, we would have experts testify with a cash flow saying, based upon this reorganization of the company is going to have sufficient cash flow, will be making money, they can pay the lease, and so on and so forth. But the landlord is entitled, if you're going to stay in the premises, to get all of the rents paid back that are past due, and to be comfortable that you're not going to go in default the first day when you come out. If you're in a shopping center, there are additional requirements. We won't get into detail. Now, there are other contracts that you can also assume or reject. It's not just a lease, an executory contract, which is anything where there's going to be performance in the future. So let's assume that you have a consulting contract with me in which you agree to pay me, $10,000 a month for the next year. And after 2 months, you file bankruptcy. You can go to the court and say, I want to terminate Berman's contract. We're done. And I'm not going to pay him the 10,000 for the next 10 months. Or you can go in and say, yeah, I like Berman's contract. I want the court to allow me to continue with it. The time period for that is usually set by the court in some sort of a hearing, but there are contracts other than leases that you can either decide to get out of or stay in. If a manufacturer has a contract to buy a certain amount of goods from a vendor, he can say, that's not a good contract. I can get a better deal elsewhere. We're done. So you do have the power in the bankruptcy to get rid of bad contracts. And if your landlord files a bankruptcy and says, I want to get rid of Berman's lease because he's paying me $1 a foot when the market's $20 a foot, I can continue to stay in the premises for the rest of the lease term as long as I keep paying my $1 a foot. And if the landlord's supposed to, for example, shovel the snow in the winter and he doesn't do it, I do it, I can say, okay, I had to pay Bill 50 cents to shovel my front walk. So instead of paying $1 this month, I'm only going to pay 50 cents. So you have, as a tenant, you have a protection if the landlord files a bankruptcy. But the rejection of contracts is a very key point and key thing to consider if you file bankruptcy, because you're there, oh God, I'm stuck with this obligation for the next 2 years. No, you can get out of it if appropriate. Okay. The court also, through, you as the debtor are supposed to, most of the time, the creditors committee will do it because the debtor doesn't want to. You can avoid certain transactions that happened before the bankruptcy. So the most common one is called a preference. So let me give an example. I sell you monthly $10,000 of goods, and you fall behind in your payments to me. And 2 days before you file your bankruptcy, you bring me current. All right. So to the extent that you brought me current, not in accordance with my terms, and it occurs within 90 days prior to the bankruptcy, the court can come to the vendor and say, you have to disgorge that payment because the purpose of the bankruptcy is to treat all creditors equally and fairly within their class. In other words, if you're a secured creditor, versus just an unsecured creditor, the unsecured should be treated the same. So you have to pay back that amount because it wasn't paid in the ordinary course of business. They owed you the money and they preferred you over other claimants. And so then I have to pay back the money, and the money becomes available for all creditors. If you're an insider, which means basically if you're the owner of the business or an officer or director, anything you get on account of an antecedent debt within a year can be disgorged from you. So that if you made a personal loan to the company in 2023, and in 2025, you see the company's not going to make it, I'm going to pay myself back. That money is going to be able to be disgorged from you. So that is one thing. When you get into bankruptcy, somebody, whether it be the creditors or a trustee or you yourself, are going to go through all your books and records. And typically what I saw happen was they'd write to everybody that got a payment within 90 days and say, that was a preference, you have to pay it back. Now, they all weren't preferences. If you pay, if I sell you on a 30-day terms and you pay on 30 days, then that's not a preference. You're just paying according to terms. It's the antecedent debt that's not paid in accordance with terms that's the focus of that. So a lot of people try to say, I'm going to take care of you, don't worry. And they take care of them, but they end up causing more of a problem because they have to go hire an attorney. They have to disgorge them. They're involved in the bankruptcy. Fraudulent transfers transfers made for less than reasonably equivalent value. So let's assume that your business owns its real estate and there's a $200,000 mortgage and it's worth $500,000. And you say, I don't want to lose this real estate. I'm going to sell it to my friend John. He'll give me $300,000 for it. I'll pay the mortgage and I'll have $100,000 for the business. And John and I have a side deal or something. The point is, if John buys a $500,000 piece of real estate for $300,000, the court can set aside that transfer saying he did not pay fair value, and therefore we're going to transfer the real estate back to the company. It will be available for creditors. John will get his $300,000 back eventually, but he's not going to get to keep the extra $200,000. A lot of people do try to, as part of the planning, transfer property so that it won't be within the reach of creditors, and that's fraught with problems. You're going to have to know what the value was. You're going to have to prove, and fraudulent doesn't mean actual fraud. It really means you're not getting fair value for the property. There were a lot of cases I was involved with, once again, with bigger companies. I'm sure you've all read about how these investment banks would come in and they'd buy, say, Toys R Us. That was one I was involved in. For example, they put in some cash, but then they'd leverage the assets of the company in order to get the rest of the cash to buy the company. And then the argument was the loan from the bank to the company a fraudulent conveyance because the company didn't get any benefit. There was no value to the company. The value went to the stockholders. So those got fought forever, and you had to prove that it didn't matter, the company was still solvent and could pay its debts, but obviously if you ended up in bankruptcy, there were issues. So fraudulent conveyances take various forms, but you need to be aware of them as part of your planning, that you're not doing something that looks good in the short run, but in the long term is going to come back and bite you or whoever you're dealing with. Also, sometimes like if you have money on deposit with a bank and you default in your bank loan, they'll take the money out of your account and apply it to your loan. The bank can sometimes be forced to disgorge that if it's improved its position. So in other words, the bank's owed $100,000, you have $10,000 in deposit, they take the $10,000, now you owe $90,000. But if the bank's deficiency improved. So let's say before it took the $10,000, you never had more than $1,000 in your account. So now instead of having a $99,000 loss, the bank has a $90,000 loss. The bank can be forced to disgorge that $9 because they shouldn't have improved their position during that period. So um, there are lots of powers. The benefits here is you get the automatic stay. People can't sue you. You've got the right to get rid of contracts you don't like. Uh, you can do various things in the bankruptcy, but it also can come back to bite you or people you've dealt with as well. Um, all right. So now we've talked about bankruptcy in terms of a business that wants to continue and reorganize. And that would be a Chapter 11 reorganization bankruptcy. Uh, there's also a Chapter 7, which is a liquidation, where all you want to do is say, I'm not continuing with this business. Um, I'm going to throw the keys on the table. The court will appoint a trustee. The trustee will come in and liquidate all the business's assets, pay himself his fees, of course, and then distribute money to the creditors in order of their priority, secured creditors, taxing, unsecured, whatever. You can also use a Chapter 11 to do a liquidating plan. That gives you a little more control than just flipping it over to a Chapter 7 trustee to liquidate. But I'm focusing for most of this discussion on companies go into bankruptcy, they have a problem, they want to restructure the business and come out and continue operating. And that's where you come to a Chapter 11 process. During the COVID years, the CARES Act put in special provisions for small businesses, and small businesses were defined as debtors having less than $2.725 million of debt. That amount was increased to $7.5 million by President Biden, and that $7.5 million increase went through mid to late 2024. I don't think it's been extended beyond that. But the purpose of this was to say, if you're a small business, you don't have to dot all the I's and T's that a larger business has to do to come out of a bankruptcy. And, for instance, I've listed a few of the things here that are different. Usually if you're in a normal bankruptcy case, your creditors will get together and form a committee of 5 or 7 creditors who will take action on behalf of all the creditors. They'll hire their own attorneys. You'll have to pay your attorney, the creditors' attorneys, and they'll have a lot of say in the court. In a small case, there is no creditors committee, and there's nobody for you to have to pay other than your own attorney. Also, in a regular bankruptcy case, the court can appoint somebody to run your business if it doesn't think you're doing a grossly bad job. Not just that you did a bad job. If you did a great job, you wouldn't be in bankruptcy. But if things didn't work out, that's why you're in bankruptcy. But you really have to be gross mismanagement, or there's some part of your operations that they want to investigate, and the court can appoint somebody to investigate or run the business. That doesn't happen in a small business. And in a typical Chapter 11 bankruptcy, within 120 days, you file your plan. And your plan will talk about, this is what I'm going to do with my creditors. I'm going to pay the people who have liens 100% in full over 5 years with interest at 2% per annum. I'm going to give my creditors 10 cents on every dollar that they're owed, so on and so forth. In a small business, you have 90 days to file that plan, not 120. So they tried to, since they're giving you less hurdles, they're trying to speed up the resolution, and it's in your interest to get out as well. I mean, I've had bankruptcy cases extend for 2+ years, and after 2 years, you really wonder if they're going to make it. The next thing is, if you have a plan in a normal bankruptcy, you have to prepare a disclosure statement, which think of it as SEC registration statement before a company issues stock. You talk about the company, its history, what caused it to go bankrupt, what its plans are, how it's restructuring, how it's reorganizing, how you're going to treat creditors, what the risks of the plan are, what the, what would happen if there's no plan and you just liquidated the company. It's, usually hundreds of pages, depending on the size of the company. Here, you don't have to do that if you're a small business. So, and once again, it's the cost saving and easing it for you. Um, Also, in your plan, only are to give you the history, the liquidation analysis, what happens if we don't go, your projections showing that you can make future payments, and that you're going to use your future earnings to pay whatever promises you made. So there's a lot more to a typical Chapter 11 plan. So they've sort of made it easier for you to put a plan together. And and then in a normal plan, there's a priority, and who gets paid what. Like the unsecured creditors can't get paid until the secured creditors are paid. The stockholders can't get paid or retain their interest in the stock unless both the secured and unsecured creditors are paid. And there's a priority. And while there are provisions in the bankruptcy code that allow you to litigate and get the court to agree to change the priorities, in general, there are the priorities. And you need your plan to be accepted by 2/3 of each uh, class and an amount and a half in number. So if you have, for example, $10,000 of unsecured creditors, you would need 6,667 6,670 of them to agree, and they'd have to represent, if there were 10 creditors representing 10,000, at least 5 of them would have to agree to the plan. And uh, also, the plan normally requires that you pay administrative expenses at confirmation. So that means you'd have to pay all the lawyers, your lawyer, the creditors committee lawyer, uh, any other administrative claims that you had. So, for example, an administrative claim would be if you were buying inventory during the proceeding, you'd have to pay your inventory purchases that were outstanding that you bought post petition, that you acquired post petition. If you have wages that you didn't pay post petition, you have to pay those. Now, most plans allow you to just sort of pay the employees and the inventory purchase in the ordinary course. But technically, without agreement, you'd have to pay them all. And then you'd have to pay any unpaid taxes over no more than 5 years. And as I said, there are ways around it, which are very complicated. I'm not going to get into them. But in a small case, instead of paying all those administrative claims at the closing, you can pay them over time. So it eases the cash flow burden on you at the time of closing. So let's see, I think, all right. All right, and then you have certain obligations to file tax returns and financial reports, but that's just administrative. It's not a big deal here. And we talked about Chapter 7 liquidation. Before I go on, Teresa, are there any questions?
I have a general question, so
Okay.
you want to do that now or wait?
Yeah, no, we can do it now.
So I had somebody that asked about getting a lawyer in general, and does it have to be industry specific? How do you find a lawyer?
Well, if I was still working, I'd say call me, but there are, first of all, the first thing is you want somebody that has bankruptcy experience. That's the key thing, because the bankruptcy court, the provisions of the code and the rules of the court are very detailed, and you need somebody who
Oh,
has experience.
hold one moment. Not
Mhm.
necessarily in bankruptcy, just in general.
Oh, in general, okay.
Yes, and then does it have to be in someone that knows your industry? Is that important?
I'd say it depends. I don't think it's essential that they know your industry, but it does help. Somebody advising manufacturer. There are different issues with a manufacturer than there would be with a retailer. So it is important, it will save time and help if they do know your industry. But I think if you get a good business lawyer who, understands cash flows, understands, uh, business in general, you can probably uh, have him learn the specific idiosyncrasies of your business. But so the answer is, if I have a choice, yes, but you don't always have that. And, you know, uh, it's important to get somebody who knows business, knows issues that arise in business. Whether you have a manufacturer or retailer, if you're dealing with employees, there are similar issues, right? And if you're, dealing with landlords, there are similar issues. The different issues may be, what do you need for a manufacturing process? What do you need for retail? How much inventory do you need for retail? There may be some details there. But oftentimes I find that lawyers work, not to keep throwing money on you, but there are business consultant firms out there who work with companies that are in need of some sort of restructuring, reorganization, and a lot of the consultants will have specific information about your industry and know about your industry, and they can, pass that information on in the appropriate fashion to the lawyer as well. So depending upon your size and and whatever, there I could recommend various business consultants. There's an organization in Massachusetts, well, it's a national organization. It's called the Turnaround Management Association. It's a group of professionals, lawyers, bankers, consultants, and they deal strictly with businesses who need some assistance in restructuring or dealing with specific financial problems that they have. That would be a good organization to call to get, names of people in that industry to help you. But I always viewed, maybe it was a selfish view, that hiring somebody competent who understands business, they can always pick up on some of the niceties of your particular segment.
Does SCORE offer a referral list?
SCORE does have a referral list. The answer is, we don't, these are people that either SCORE mentors or clients have said did a good job for them. Some of them may or may not be bankruptcy attorneys. Some of them may be corporate attorneys. I mean, I know we have some employment attorneys. I do know when somebody asks me for a referral of a attorney that could help in these types of situations, I have, some people I worked with when I was in practice that I can refer them to. So the answer is yes. And we typically won't give you just one name. We'll give you two or three names so that you can chat with a couple of people, see what they say, see who works with you well. And uh, so the answer is we do have a referral list, for accountants, for lawyers, for insurers, for tech people. We have all sorts of referrals we can give you or get for you.
It's probably best to get that from one of your mentors so that they
That's right.
know what
That's
it
right.
is that you're going after. Okay, I actually have a bankruptcy question. Okay, prior to filing for bankruptcy, should you seek legal advice? Who pays for the attorney before the filing and who pays after the filing? How much should a business set aside to pay the attorney?
Okay. The quick answer to one and two is the business pays for the attorney before the bankruptcy and in the bankruptcy. Um, Now, if the business doesn't have cash, you as owner may have to front some money for the attorney. How much do you need to set aside? It depends on the size of your business. To give an extreme example, like in uh, the Circuit City or Toys R Us cases alike, I believe that the debtor's attorney got retainers of seven figures. But That's not going to be the case for a small business. I think, depending upon how contentious the process is and or how quickly it goes, I could see, you know, $25,000, maybe more than that, depending upon the business. So there are many factors, size of the business. Are you going into the bankruptcy just to liquidate? Are you going into bankruptcy to reorganize? Who are your creditors? Are they working with you? Are they against you? So I think that that's a hard question to specifically say, but as a small business, I think you should think of 25,000 and hopefully it will be less.
All right, that's all the questions I have right now.
Okay. Um, all right, let's see. Well, it's just about 1 o'clock too, right? So, um, in any event, I think I just want to harp again on the fact that bankruptcy is not your first choice if you have problems. You know, hire a professional, you can do, and you don't have to hire a lawyer necessarily right away. Although if you think you may go to bankruptcy, you want to go both fronts at once, the lawyer and the business consultant, as I was suggesting, like the Turnaround Management Association. And they have strategies. They've worked through these before. I had a client the other day who called me who was thinking he was filing bankruptcy, and before we're done with the call, I had given him 5 things he could try to do before he filed bankruptcy in terms of, meeting with creditors, negotiating with creditors. He's a small business, so he didn't have, a lot of creditors, but he had a couple of troublesome creditors he had to meet with. And, there's a lot of things you can try to do before you file bankruptcy that will be cost efficient and in the long run beneficial. For you. So I think that would be my general advice. I have not touched here. There's a uh, separate chapter called Chapter 13, which deals with individual consumer bankruptcies. I've been focused on business, but if you personally need to file a bankruptcy, there's a whole other set of rules for consumers. And that's the subject of a different conversation, but you should be aware of that uh, a consumer bankruptcy has different rules and different abilities for the consumer to uh, reorganize and restructure its debts and come out of bankruptcy. So um, I think, Teresa, that there is so much specifics and so much details. I think that's a big overview.
Okay. I do have another question. It's a good one too. Is it a mistake to loan the company money if you expect bankruptcy is coming?
Um, well, the first thing I would say is if I were going to loan the company money, I would do it and get a lien on the company's assets so that you're not unsecured. That doesn't mean that it will not be challenged, but at the very least, if I give the company $10,000 because it needs it to make a payroll, and then it goes bankrupt, I'm in the same boat as probably in a worse boat than all of the other trade creditors because the trade creditors will get paid first before me. So if I lend the company $10,000 and say, give me a second mortgage on the real estate so that I know I'm going to get paid back, that's a safer position. The question is, what are you lending them the money for? Um, if it's to pay payroll, you're probably going to be personally responsible for that if the company doesn't pay it. Um, so therefore, uh, I would make sure that the payroll got paid. The same with any withholding taxes and the like. If you're doing it to buy more inventory, I'm not sure, depending upon when you said if you think the company's going to file bankruptcy, question is when, is it filing in the next 2 months? Or you think it's going to have to file in the next 18 months? If it's 18 months, then, maybe you could put some money in even on a secured basis. But if it's 2 months, I think I'd be talking to my professionals and not putting money in. You may need to put money in the bankruptcy, but that can be protected better than it can by you putting in before the bankruptcy.
Okay. All right. Well, then we will wrap up. We're hit 1 o'clock exactly on the nose. So thank you everyone for joining us. Please remember to reach out to a SCORE mentor if you have further questions on this topic. I know it's a difficult topic to go over in an hour. So reach out to us and have a great day, everybody.
Thank you.
Bye.